State aid still involved?
Not on my side, no.
Is state aid involved at all? Medicaid, My Child, anything?
No.
Okay. And you guys deviated to zero. And there was a payment plan that was arranged at about the same time that you would pay $50 a week, sir. For
so what happened was she said something about paying. And I'm like, we're trying to close the case. We've been trying to close the case out for like a year now, like filing stuff, and it just hasn't closed. So, and then when we met with her, was like it should be closed and stopped. And she was like,
if there's no state aid, if there's no state aid, we can do that.
Okay.
But you still owe the arrearages.
Right, understand that.
Some of those arrearages are owed to the state.
Right, understand that part.
Okay.
Because she was trying to forgive me for my arrearages as well, for her half.
Right. Well, and ma'am and Ms. Godines, you were willing to forgive his arrears?
Correct.
Okay.
But she kept giving us a hard time about it. I couldn't do it.
Well, it's because I'm going to have to confirm if state aid is involved in the front of the court has you listed as state aid, you can't deviate. Contact the front of the court and get their input on this and maybe have them show at that meeting to discuss, because you did get a deviation signed. The $50 a week payment plan that you set up, Mr. Colvin, will be in place. Okay.
Okay.
So that's going to, until we can figure out what arrears are there.
Okay.
All right. And I'll contact the front of the court and find out what's going on. And that way I can tell you, because if they have state aid listed, they're not going to let you deviate. They're going to go with the child support guidelines. And that's what my thought was, is what they did.
Okay. I apologize. But they're saying I got to pay child support now. I am so confused on that part. I never agreed on it.
Oh yeah. That's what was signed.
Yeah.
It made you the payer.
I never agreed on that. Like, I'm so confused. I'm like, where did this come from? Yeah.
You signed it.
See, what happened was,
where did I sign this? Because
you signed it on July 10th.
Okay, so I went. Was this with that lady? I forgot her name when we sat down, because when we signed
the deviation says that you would pay. The problem is that then you deviated to zero.
Right. That's why I'm so confused.
I'm kind of confused too. So, but
so what happened was we went and met with her.
Yeah. Well, you guys signed this, and that's what Esmeralda, the payor.
Right.
Okay. This is what happened.
A legal assistant to help us with the paperwork. We made sure that they knew that we wanted to make it zero.
She knew that as well when we sat down and talked to her, but she was
that's what they did. They set it to zero. The problem is the front of the court may deny it if state aid's involved, and they will run with what the child support guidelines were. But normally they do not make a person pay who's on state aid. So that doesn't make sense either. So what I'm going to do is we're going to set this for a settlement conference.
Okay.
Okay. Esmeralda, you think you can make sure you'll be able to connect next time?
I'm gonna have somebody guide me with this, because I don't know.
No problem at all. I mean, what we're going to do is set this up, and I'll try to remember to set it up so that I'm working from home, because I can't do what I'm just doing right now at my computer at work.
Okay.
I can only do this with my computer at home. So I'll try and set that up, and I'll try and contact the front of the court, and we'll see in about 3 or 4 weeks, and I'll see if I can get this cleared up for you. Okay.
Okay.
Because there's a problem.
I have a question.
Sure.
She said she gave me a benchmark because she said this stuff wasn't filed. She said if it wasn't filed by the end of the month, that she was giving me a benchmark for non-payment.
What wasn't filed?
This our deviation down to zero.
Okay.
We filed it that day, and when she called me on the phone at the end of
it was received on July 11th by the court.
Right. That was probably the next day. Well, August 1st or 2nd, she called me and was like, "I'm putting a benchmark."
It wouldn't have been processed by August 1st. It probably takes 3 weeks. It takes 2 to 4 weeks to process.
Okay. Well,
we just go in the court file, and then it automatically gets implemented. It takes some time. It's got to
understandable. And I was trying to explain it to her, and she wasn't trying to. She wasn't listening to, or she didn't care what I was saying.
I'm listening, and we're going to have a settlement conference, and then we'll see if we can clear it up. Okay.
Okay, can we get the bench warrant taken off since I did do what I was
That's what
supposed
I'm
to
going
do?
to call. I'm going to contact the front of the court about the bench warrant.
Okay,
They're the ones who issued the bench warrant, so they're the ones who are going to have to explain why they did it and what's going on. It may be that there was a misunderstanding that the paperwork crossed paths,
okay,
that they didn't have it in time, so they issued the bench warrant, not realizing that this had been processed.
okay.
Okay.
All right, thank you, sir.
We'll see you, and we'll try and get it done soon. All right.
Okay.
All right. Thank you.
Take care of yourselves. Good luck.
Bye-bye.
See you again soon. Bye.
Bye.
All right. Let's go back on normal channels here, so I don't bother my wife and daughter.
As my wife just said, I was already bothering her. Oh, okay. So we're back on headset. Okay,
Yes.
next case.
We can do Lee
Okay.
versus Wesson.
We have both parties here.
Yes.
All right, give me a second. I gotta
Okay.
find.
Sorry.
You know, the stack is tall right now, so I gotta hunt down the
Yeah.
file within the stack of. There we go. Got it.
Oh my goodness! And it's just as I was bringing in Miss Lee, she disappeared.
Oh, she's a magician.
Darn. Oh, this might be her
Okay,
coming in as an iPhone. We'll see if it's her.
no problem. P. Ma'am, I've read your motion. It appears that you believe that his mother is exercising a majority of the parenting time. What's going on? How much time do you think? Because you don't seem to have. You're making really blank statements about what you believe. So what's going on?
Yeah, it's not a what I believe. It's a what I know. This is an everyday thing. This
Yeah.
has always been his mother exercising the rights. This has been the child just turned 7. It's always been me and the mother. Doctor's appointments, conferences,
Well,
anything.
what is your work schedule?
Right now, I'm not working.
Okay, Mr. Wesson, what's your work schedule?
I work Monday through Friday. I work starting at 5 a.m. to like 1 o'clock.
Okay, so are you available for doctor's appointments?
Sometimes I'm not. Just depends. I'm not available for all doctor's appointments. No,
Okay.
I don't take them to school. I pick them up from school. They're my week.
You pick him up from school during your week?
I pick them up from school every day during my week, and I attend.
Miss Lee, what's your understanding of that?
My understanding of that is that I have another child that goes to the same school as the child that me and Dominic shares, and I'm at the school every day picking up my child, my daughter, and the grandparents are picking up our son. Now, for the first time in a very, very, very long time, I seen him yesterday picking up our son, and I was pretty shocked. But like I said, that was the first time in a very, very long time.
I guess my questions become this. You had a hearing with the judge in 2023 over this similar issue that you wanted to disallow the grandparents from watching the child during daycare, and then you couldn't find daycare. You lost your job because the grandparent wasn't watching it, because the grandparent was also watching the child during your time, correct? Is that still happening?
No.
Who's watching the child when you have the child?
When I have the child is at school or at the Boys and Girls Club.
Okay, because you're not working right now. How long have you not been working?
I just stopped working. It's just been a week.
Okay, so you're going to be going back to work. What is your normal work schedule?
My normal work schedule is from 12 to 8:30, 12 p.m. to 8:30 at night.
Okay, and who watches the child when you're at work?
So usually I'll get off. I'm work for Urban League. I'm a cure violence interrupter.
Okay, that wasn't the question. Who watches the child when you're at work?
He's at school and then the Boys and Girls Club until 7 p.m. and then I'm done.
Okay, so you have the Boys and Girls Club watching the child.
Yep, from 3 to 7. 3:30 to 7.
And he has his parents watching the child when it's necessary during his time.
And
it's my understanding that he lives with his parents, correct?
I'm not sure.
That's correct.
Okay, I was going to say that's what the file says. You know, at this point in time, ma'am, you had a hearing in 2023 with the judge that granted the same relief. The front of the court issued a recommendation in March of this year doing the same thing, all involving the grandparents and who's watching the kid. You both have the kid being watched by third parties upon occasion. And he's living there, so he's got to be with the kid. I'm afraid your motion's denied at this time. This has been
He does
reviewed.
not
This has been reviewed
exercise
twice in the
any.
past year and a half.
And I'm going to keep filing motions until y'all do something about it. Y'all want me to share 50-50 custody. Y'all want me to share 50-50 custody with a person that is not exercising their 50-50 custody. It just does not make sense to me. Ask him, what did he do for the child's birthday? Because I know that I threw the child a party, as I do every single year, while he buys a toy and calls it a day.
You've had this reviewed by the court twice.
Yeah, and I'm going to keep on coming back to court, or I'm going to give my rights up, or I'm going to ask for lesser time.
And that's kind of the argument you gave during the trial with the judge, is that you were just about to give up your child.
Keep dealing with it. I'm not going to keep dealing with it. If
well,
y'all are not
denied at this point, you may object. Your motion is denied at this point. You may object to my ruling. This is a recommendation.
If you're not going to make him exercise his rights, why do he have them? That doesn't make sense to me.
According to the file, he is exercising them.
No, his mother is exercising his rights.
You both are using third parties for daycare and other choices.
Work hours.
All right. Have a good morning. Good luck.
You haven't asked during nothing outside of work hours.
Your Honor.
You haven't asked about nothing outside of work hours.
Thank you.
You're welcome.
I figured you'd get that
quick
enough, because I'm sorry, but you've had this reviewed. You went through a trial with the judge, and I mean, it was barely a year ago, and then the front of the court made a similar recommendation a few months ago, and she was arguing that she was going to give the child up at one point because she couldn't find daycare because she needed his parents to watch. I'm like, okay, no. All right, next. C.
All right, we can do.
Sir, this is your motion. What do you care to add to it?
Well, basically, I I have my child since I have her full time since March, the end of March, and I contacted friend of the court about abating my child support because I was paying child support. They went through with the abatement.
Right, the child support got lower. No, that's 2021. Are you Are you talking about March of 2021?
No, March of this year.
Because in March of 2021, they abated it for you having like 208 overnights, and the child support was set at 107 and 30, respectively. So now you're saying you have the child full time?
I have the child full time as of March of this year.
Ms. Gaetoni, is that where the child is at? Is the child with him now?
The child's been living with him for the past few months, yes.
Okay. So this needs to be reviewed for child support now. That's what you need. And the front of the court doesn't automatically do that. You have to ask the court to do that.
Okay, yeah. Well, this particular issue that I filed the motion for.
I understand what you filed the motion for. They have corrected it. They they realized when you filed something that they did an audit.
Yeah.
And they realized that they missed one part of the order because it was a 2-part order.
Yeah.
So they redid it. So it lowered the arrearages down to 2,102 from the 2,000 whatever it was. But they put in the correct order. But now we need to correct that order because you now have more than that. So we now need to send this to the child to have a further review of child support to find out what it should be.
Okay, yeah. I basically didn't want to pay the $2,000.
Well, what'll happen is if she owes you, it'll come off what's there. The law does not allow me to retroactively change child support. Okay, I can only change it from when you file the motion.
Okay.
So you've been trying to do something, but you've been asking the wrong government place to do it.
Yeah.
Yeah. So the front of the court can only do statutorily what they're allowed to do. So you have to actually ask the court for changes of court orders.
Okay. So
right,
do today anything?
I can send this because we're here on a child support issue. I can send this to the front of the court for a child support review beginning on August 1st.
Would this be a new case then?
No.
I thought that after this was settled, the case was closed.
No. How old's the child?
11.
11.
No, the case isn't going to close until the child's 18 and out of high school.
Okay.
I lose jurisdiction of the child's custody and parenting time when they turn 18. I lose jurisdiction of the child support when they're 18 and out of high school. Okay. So no, the case does not close. All right.
I did file
now, the two of you can agree to all kinds of things as long as state aid's not involved, but that's between the two of you. Okay. You did file for what?
I did file for a review. When I filed this motion, and I did receive paperwork just yesterday.
Oh, so the front of the court's going to review it because it's been over 3 years?
I believe.
All right. Because that hasn't made it to the file yet. I'll double check with that.
I have the paperwork right here.
Okay. When was it filed?
Let me check.
Yeah, because you can request a child support review anytime after 3 years, just because 3 years is considered a change of circumstance.
In
In any event, we're going to get this reviewed one way or the other.
Okay. It says here at the top, case number 1802114 DC.
When is it dated? And it should be signed by Megan Lipford.
Date at the bottom of the page is 9/9/24.
Okay. Alrighty. I'm gonna set this back as when you filed the motion to August 1st. So that's as far back as I can go. Okay. So I will coordinate with them to make sure that the start date is appropriate. They will issue a recommendation. They should be contacting you both shortly. They'll need your current pay stubs and parenting time arrangement.
Oh, okay.
Okay. Any questions from either of you?
No, thank you.
Okay. Have a good morning. Good luck.
Thank you.
Take care. All right. Next.
All right.
Is she here at least?
Yeah, she is here.
All right.
She just has not connected to audio. There, she looks like she's connected now. Ma'am, if you could unmute. How about now? It looked like you connected to audio.
Does she have like headphones that she's accidentally?
I can't. She's in a dark area. Okay, yeah, she's putting something in her ear. Now let's see if she can hear me and if she's got some kind of a microphone. Lindsay, how about now? Come on, Miss Holloman.
Oh, she said she can hear us.
Right, she should be able to hear us.
Yeah.
I wonder if she has a microphone. All right. Back to the other way. Miss Holloman, can you hear me? All right, hold on. I'm switching speak.
All right, can you say something to make sure that my clerk can hear you?
Hello? I can hear you.
Okay.
Yes, I can hear her.
All righty. So I'm just using my phone and my speakerphone, and I've switched speakers on my computer so that she can hear us. So we are here in the matter of Holloman versus Ward. Sir, this is your motion. What do you care to add to it?
Good morning, Your Honor. I just came here today. I would like to get visitation of my daughter, Hannah. I was seeing her up until September 8th and 9th of 2023. On those days, I was invited to Lindsay's place. At the time, she had an apartment. I stayed there 2 days with her. Prior to that, she was asking me to help her out with rent so she didn't lose her apartment. After I said no, she took my days away with Hannah.
What that your motion says that you wanted to enforce the pickup and drop off point. None of this is in your motion. It's been a year since you've seen the child?
On and off, I've been seeing her. I have a whole thing wrote out. I've been seeing her.
Well, you didn't send it to the court. All you said in your motion was that you wanted to enforce the pickup and drop off. And it doesn't even sound like you guys are using that. It sounds like you're using the houses.
No, like there's 2 times we met up at the police station. And then after that, we weren't even going by the court order because she was letting Hannah stay the nights with me and everything. Like, she took away my visitations. I'm just trying to get my visitations back.
When was the last time you saw the child?
Huh?
When was the last time you saw the child?
I seen Hannah a few weeks ago, but that was because she was at my mom's without Lindsay knowing. But we shouldn't have to go behind Lindsay's back, for me to see my daughter.
All right, Miss Holloman, what's going on?
So we went to court on June 22nd of 2022.
Yeah.
And he was supposed to do monthly therapy and go to the YWCA called Men Choosing Alternatives to Violence.
Right.
But he never completed those classes. So that's why I stopped meeting at the pickup spot.
Okay. Mr. Ward, what happened? Why didn't you comply with the requirements of the order?
I did the YWCA thing. I completed all that. She knows that. And I started my class.
It doesn't sound like she knows that. Do you have the certificate of completion?
Through the YWCA?
Yeah.
The class with where somebody was there with me visiting my daughter?
No, not that.
You were supposed to enroll and put on a waiting list if the class is full with the YWCA called Men Choosing Alternatives to Violence by July 15th of 2022, and you were supposed to complete the class by December 31st of 2022.
You know why I didn't do all that is because she didn't even go by any of the court order. She wasn't even.
If you're not going by the court order, what am I going to do with either one of you?
I work full time. I work 7 days a week. There's barely any
prerequisite.
Do anything.
You had to get this done before your parenting time would increase.
But we weren't even going by the court order. So she was letting me see my daughter and get my daughter. Like, this is all a game to her. This is all a game.
Sounds like it's a game to both of you.
It's not a game. I've been fighting to try to get my daughter for almost 4 years. What do you mean this is a game?
You're the one that said it's a game, but I'm looking at it going, neither one of you are compliant.
I don't have time for all this. Like, I have to take off days just to do this. I have to take off days to go see my daughter behind her mother's back. Like, I have to do all this stuff to take off work. Like, I work 6-7 days a week. It's a game to her. She wants me to do all this stuff when she knows I don't need it.
Right.
Like, what about her? She's letting my daughter's teeth rot out of her head. My daughter has 4 silver caps in her mouth right now because her mother.
She went to the dentist and had those put in so that her
13 days of school. Explain my daughter missing 13 days of school already.
All right, ladies and gentlemen, let me be blunt. None of this is in your motion, and all of a sudden you guys want to throw a kitchen sink at me. All right? That's not the way this works.
My motion was to get visitations of my daughter. That's what I put on there.
Okay, in that case, my order is going to be to comport with the order that was previously entered, which means you have to comply with that order as written. So I'm going to restart that order. Let me see how I'm going to restart the order, and I'm going to change the dates to current dates.
Well, I live 3 hours away, so I don't know how I'm going to do all that.
Really?
Yeah, I work somewhere else for the summer.
Okay, what about the winter?
The winter, I'm going to try to move back down to Grand Rapids, yes.
Okay, so you'll be down here.
I'm going to try to, yes.
When does that start?
My job ends October 31st, and then there's like a week of cleaning.
All righty. Well, I'll adjust the dates appropriately, but I'll follow the previous court order and have you reset that and get it going. Okay? That way you can have your parenting time appropriately. This time, both of you are going to comply with the order. Okay?
I feel like she needs to do something too because she's not a fit parent. She needs to take some sort of classes too because this is unfair. She's neglecting my child. My child doesn't even want to live with her. She wants to live with grandma and dad, and she tells me that. I wish I could have my daughter here to tell you.
All righty. I'm going to reset the order from June 22nd, 2022, and I'll update it with current dates. And then comply with it. And that's what your order was to comply with the previous order, which is what I'm going to do.
Okay, well, it was the whole order. I feel like she needs some sort of classes too, Your Honor.
That's not part of the order. And it's not part of your request. Your request was to enforce the order of meeting point. So I'm going to enforce that in compliance with that court order. Read the whole order so that you comply completely. Okay? Good luck, everybody. I'm granting you what you've asked for.
Can you email me the order?
Yeah, I'm going to because I'm going to have to retype it to put in new current dates.
So up until then, like, I still had visitation with my daughter. So.
Well, it sounds like you guys have not been following the court order up to now. So if she's willing to give you some visitation, she's more than welcome to.
But that was court ordered. I had visitation.
And I'm court ordering the visitation to be reinstated. Read the court order in its entirety. Because part of it is you have to comply with that YWCA. Okay? Good luck.
Yeah.
Thank you.
Good luck.
DP. Your daughter Navaya graduated high school last May, correct?
Yes.
And she turns 18 on October 31st of this year.
Yes.
And the child support order incorrectly states that her graduation is in 2025.
Yes.
And forgive me for asking all these questions because the file is not with me. It is probably in transit from across the county of Kent, because they store any files over 10 years old in a trailer with a lot of spiders. So somebody had to go get it, and I'm sure I'll find it next week sometime. But in any event, it's appropriate then to change the end date to October 31st of 2024 for the child support. Child's 18 and out of high school. Once that happens, we stop support. So we will do that, okay? Motion's granted.
Yes, sir.
All righty. You have a good morning, sir.
You too. Thank you. Am I all set?
You're all set.
All righty. Thank you.
So I'll probably need a UCSO from you, Miss LeVay.
Yeah, that's fine. So my question, you said the graduation date was 10/31, but
I'm sorry. No, her 18th birthday is 10/31. She graduated last May.
Got it. All right.
Yeah, wrong Williams. For DP. I will note Mr. Jackson, the moving party, is here. Miss Britton is not present. This matter was set for hearing at 8:30. It's now 9:14. I've read your motion, Mr. Jackson. What else is going on?
Well, last time I filed for this.
Right.
I want to say it the best way because I don't want to make it seem like I'm downing Miss Britton, but last time she never gets in contact with me. I could never get her to.
Well, I sent you both to the front of the court, and they both wanted you to be present, and neither one of you showed up.
Yeah, because I didn't know. I thought because from what she was telling me and what she was showing me, I thought that we could do it by phone. We both called by phone and said that we wanted to deal with it ourselves. And
so that's why you terminated it.
Yeah, because she came to me out of nowhere saying that she had got into an accident and and things happened with her, and that's the reason why she wasn't contacting me.
But you still haven't seen your kid, your child.
Exactly. Like we had an agreement that I'll be more involved. I'll be in school and stuff. And
well,
when
that
school
agreement
started,
that agreement is not in writing, and the court has nothing to enforce. So, let's start this over again, and do not call the front of the court and terminate it. This time, follow through, please.
Yes, sir.
Okay, so I will do what I did last time because that's the best I can do for you at this point under these circumstances. I will send it to the front of the court, once again with the fees waived because your fees have been waived by the judge. So for parenting time, and I believe it was a parenting time and child support review.
Is parenting time deal with like joint custody?
No. Parenting time deals with parenting time.
I thought I was dealing with custody,
No.
joint custody as well. This is what I was explaining to the lady at the courthouse.
Yeah, no. This is a 2013 case. Custody was determined in over 11 years ago, and you've got nothing that would change that custody. So,
what do you mean by that? I have nothing.
I have to have a change of circumstance to address custody. You don't have that change of circumstance.
Yeah, I don't want to change full custody. I just want my part of custody.
Well, let me try and explain to you what I generally, the easiest way I can. Legal custody is kind of like the title to the car. If both your names on the car, you can't sell the car, you can't you can't repaint the car, you can't change the engine. Okay. Parenting time is basically when you're driving the car. So you get to choose the garage, the gas station, the parking lot, all of that when you're driving. So parenting time is the most important. That's what I'm sending you for, to spend time with your child.
Okay.
Okay. Custody is a word for the most part. Parenting time is what counts. I can order you to have full custody, and she has 365 days a year. It doesn't make much sense, but there's no real definition of physical custody in the state of Michigan. What it is parenting time is the most important thing. So that's what I'm sending you for. Please don't stop at this time. Please follow through, talk with the front of the court, work with them, and get a parenting time schedule. More importantly, the child deserves that. All right? So let's start it again. Any questions, Mr. Jackson? Justin, are you there? Okay. Mr. Naves, this is your motion. What do you care to add to it?
Yes, I wanted to bring to the court's attention some concerns I have about the education my daughter is receiving.
Mm-hmm. Yeah, I've read your motion. She is currently in, let's see, New Branches Academy?
Yes, sir.
All right, and that's where she was last year, correct?
Correct.
And you are requesting that she be changed schools to another school, the Granville Public School District, correct?
I'm only requesting the request that I made due to Zariah's speech therapy. Zariah has a speech problem.
Understood. All right. Bottom line, here's what the law is. The law is the child stays in the school that they were at until we can have a hearing.
Okay.
This is a joint legal custody issue on decision making. So you both have the right to request a school change. Each of you will have to present evidence to the court as to why that school change is important. Okay. At the hearing, you will be treated like attorneys, which means you will be given an opening statement, and then you will have to present witnesses to the court. Mr. Naves, you are the moving party in this matter. Okay. So it's your burden to start. So you have to present to the court why you believe that change is important and why it's necessary and why this new school that you're proposing is a better school and would be better in the best interest of the child. That includes, we're going to have probably somebody from the school testify. You're going to have witnesses brought in. You're going to have school comparisons done. Okay. Mr. Wint, once he, the only way that evidence comes into a court is through a witness on the witness stand under oath, sir. So you may call yourself as a witness. You may call Mr. Wint as a witness. You're going to have to call possibly somebody else as a witness to show why, especially somebody like from speech therapy, maybe from the current school, as to why they can't do it. And then as you question your witnesses, Mr. Wint will be allowed to cross-examine after you're done questioning your witnesses. Mr. Wint, once he has rested his case, you will present your witnesses as to why you believe it's important for the child to stay in the school the child's currently in. Any questions so far?
I'm sorry.
No, that's okay. I asked if there are any questions from either of you.
I guess for me, well, first of all, I don't know what's in the motion.
The motion is a motion basically to switch schools because he says that the current school is not dealing with her speech therapy.
Okay. So in this instance, you're telling me that I would have to have witnesses and things of that nature too.
Well, if you've got a speech therapist at the current school, it would be nice to have them testify.
Okay.
To say that they are complying, that they are doing what they can, or it'd be nice to have somebody testify as to why this child needs speech therapy.
Okay, and that's fine because it was a suggestion.
The good news is that we can have the witnesses appear by Zoom, so they don't have to come into the courthouse.
Okay, that's fine.
And the other question would be, Mr. Naves, Mr. Wint, would you want this hearing in person at the courthouse, or we can still have the witnesses show up by Zoom, but you guys can be in person at the courthouse, or would you prefer to do it by Zoom?
Honestly, I would prefer to do it by Zoom only because we have to consider the schedules of the other people.
Right. Yeah. Mr. Naves, Zoom okay?
Zoom is okay. I would like to ask, is there a way I could submit my evidence as far as
your evidence comes to the court through a witness on the witness stand. What you do is you send copies of what you intend as exhibits to the court, and you have to send a copy to Mr. Wint as well, 1 week prior to the trial. Okay? The court will not look at those exhibits until they are entered through a witness on the witness stand. The witness basically has to say, look, yeah, I printed this off from the school, or I got this from so-and-so, and then the rules of evidence apply as to whether it's admitted or not. The court does not look at it until it's properly admitted. The court does not read a bunch of paper that you just send to the court. We don't do that because anybody can make up any paperwork. I have to have a witness swearing as to what that paperwork is and why it's important and pertinent. As an example, about a year ago, I had somebody send 18 exhibits to the court. They entered 4 of them. And then were surprised about the ruling of the court. They're like, what about the evidence? I'm like, you only entered 4 of those things. That's all the court could consider. So that's why this comes with a warning. Please be advised that it'd be wise to seek the assistance of an attorney, at least meet with an attorney on how to proceed, because this is not an easy hearing. All right. I generally tell people you can walk into an operating room or an ER emergency room, and if you need to remove a splinter, you might be able to grab a scalpel and remove the splinter yourself. But if you're doing abdominal surgery, you might want to have somebody there that knows what they're doing. This is closer to abdominal surgery, folks. And the burden is with you, Mr. Naves. If you don't meet your burden, the school does not change.
That's fine, sir. I can.
I'm just trying to give the warnings because this can be a very frustrating process for all of us.
No, it's just take time. You got to have patience. That's all.
No problem. Yeah, I try to have patience.
Yeah.
But I will tell you, I've had people show up and go, yeah, I don't have any witnesses. Okay, then what do you expect me to do?
Okay, that's fine.
Yeah, I do have a trial. I do have a trial date for you for October 30th from 2 to 5. If you're both available for that.
You said October
30th from 2 to 5 by Zoom.
Okay.
Well, Zariah gets out at 3 o'clock, so that 30th, that's not on a weekday through school for us, is it?
It's going to have to be on a weekday. The court's only open from 8 a.m. to 5 p.m.
Well, which is fine, sir. I just want to make sure.
Would you prefer a morning?
Yeah, I just want to make sure Zariah is able to be picked up either.
Okay, so let's try and find you a morning one, and we'll send you that. Okay. I know that this date opened up recently because normally I'm 90 days out.
In consideration of the fact that if we do have to have people from the school to speak with us or to witness for us,
if you need to, yeah,
I'll rather consider that as well, because with an afternoon, yes, she does have to be picked up at 3 p.m., but then that is more of a time where if we have a teacher representing or anything of that nature from the schooling, they would probably prefer an afternoon in itself instead of a morning, only because of school starting. You understand what I'm saying?
Yeah, I understand, but the court only has certain times available.
Exactly.
What I will tell you is if you need to, the Legal Assistance Center on the 5th floor can help you subpoena that witness. Okay. And I have had them show up during a school day.
Okay.
So we will send you the date. I'll let my clerk find another date for you, and we'll send you notice of that date. That way you're aware of it.
Excuse me, sir.
Yes.
I would like to inform the court that the school wants to do an evaluation on my daughter, which is fine with me. I'm okay with it.
Which school?
New Branch Academy. They're in the process of the first steps of getting Zariah seen, determine what's going on with her.
Okay.
I'm okay with that.
Yeah, we would want that evaluation because then that evaluation could be submitted to the court and appropriately entered as an exhibit.
Yeah, that's fine with me. The only thing I have concerns about is with the evaluation thing, Charliqua is not communicating with me about.
Well, you have the right to contact the school.
Right.
If the school officials are doing this, then communicate with the school. And Ms. DeWint, if you have appointments like medical appointments or doctor's appointments set up, he should be invited to those.
He is in. We have a group email between Lorenzo, I, and Zariah's teacher. She emailed us, I want to say early Monday, and asked if it was okay for her. She emailed both of us and asked, was it okay for her to reach out for the speech therapy sessions, because I had already informed her of it. It was suggested last year in her pre-K year anyway from New Branches. Regardless, he was included in the conversation.
Okay. Well, if you're included, Mr. Naves, that's again, if the school is arranging this, make sure that you're involved.
Right, and that's all.
Okay.
No, I don't have to communicate because we're both there. We're both involved.
If you're both involved, then if you're getting the same communications, that's what you both need. All right. Good luck to both of you. We'll see you when that trial date occurs.
Okay. Thank you.
All right. Have a good day. Take care. 856DS. I've read the motion. Ms. Rademacher, I've been informed, has recently been retained at the very last minute. So at this point, what I have before me is enough to grant a hearing. So the question would be between the attorneys, do you want to ask the judge to do it? Do you want to agree to me doing it? And the judge has the right to send it to me. So
Your Honor,
what do you want?
Your Honor, we would be fine with you scheduling the evidentiary hearing with yourself. We have Judge Bryant. I think that would be a more efficient way to go with you.
Okay, certainly. Actually, I'm scheduled out farther than she is, so not as efficient as you think.
Okay.
So that's
any feedback on that?
Well, I have no objection to Referee Kmetz hearing this, and because of my last minute entry, that's what I get for answering a phone at 5:05.
That's that always. Hey, I remember private practice. Got to be careful.
Glad to help, because I think there's a lot Mr. Murphy and I can do possibly.
Okay, well, how about we do a settlement conference and then we'll set up a trial.
Okay, I think that would be great. And the only question I have, just based on the limited information I have, is are you saying that there is sufficient facts asserted for?
Well, from the motion that I read, there are sufficient facts to assert that there's a change of circumstance in the fact that the parties are doing a different arrangement than what was previously court ordered. So
are we addressing parenting time then, or is there significant?
Well, it sounds significant. It sounds as if everything has changed and he is primarily the custodial parent. It's on the table. That doesn't mean I'll change anything.
Okay.
It may be that the wording of custody stays the same and we only deal with parenting time and child support.
Yeah. Okay.
You know, but I think it's possible that I think from what I read, there is enough to say, yeah, custody's kind of a question here. I think Fadvarka has been met, potentially. Okay, it can still be argued at trial that it's not been met. But I think, because remember, I've only got one side of this. Correct. I didn't get a response from you.
Yep.
So, how soon do you think you guys could be ready? Because if my clerk is correct, I think I have an October 30th date for a trial. We just had one cancel. Too soon?
That would be fine, Your Honor. I think that would give Amy time to...
And we'll set up a settlement conference prior to that.
Oh, sure. Okay.
Yeah. Maybe 2 weeks beforehand. I'll let my clerk set that out. We still have October 30th available because it was available just the hearing right before this, right, Ms. LeVay?
I'm sorry. I am in my big week-long trial.
Okay. No problem. That's why I'm asking. I just offered it. I knew that we had one pop open. Yeah. So I thought so I'll have my clerk contact your offices to make sure that your schedules are open and available. We'll get you in as soon as possible.
All right. That sounds like a plan.
I'm going to put everything on the table, and it's arguable whether it should be taken off the table.
Okay. Okay. And then, so we'll be in touch on the settlement conference date as well as the trial date. Is that
correct?
Okay.
Correct.
Excellent.
Thank you.
All right. Take care, everybody. Have a good morning.
Okay.
Right, you too.
Good to see everybody. Good luck on a week-long trial.
Oh, yeah. Not really.
No, never is.
Thank you. Bye.
Bye. All righty. Next motion regarding support. This was a state incepted case, which means the state of Michigan brought this case. Neither party brought this case. Okay. You are indicating that you had some problems not knowing about this case.
Right. Correct.
And there was another case with you that was consolidated into this case.
And, what was that?
Let's see. Hold on. I'm double checking something. Yeah, never mind. There are 2 children, correct?
Children, correct.
Tristan and Sophia.
Right.
And this case was about one of the 2 children, I believe. So you had another child support case that was in existence, correct?
I have 2 other child support cases. So I have 3.
But with this mother?
No, with different.
Right. Now we're only talking about the ones with this mother.
Okay.
With Miss Montez.
Miss Montez, right.
Okay. So yeah, this case involved Tristan. All right. But there was another case involving Sophia. They combined the 2 cases together. Okay. And you're saying that they have the child support incorrect.
Right.
But Tristan is your son, correct?
Yes, supposedly he's my son.
Well, you signed an affidavit of parentage.
Yeah, I did.
Making you legal, you the legal father.
Right.
Okay. Because this was entered and you invited the prosecutor. They are not present. I will, because you're saying that they got the child support incorrect because your income is incorrect, correct?
That's correct.
All right. This is reserved back to when you first filed the motion. So what I am going to do is I'm going to have this sent. I was giving the prosecutor their argument that they had the numbers correct. Since they're not here to argue that, I will send it to the front of the court for a child support review back to August 1st, which is the longest back I can go. Okay. So I will send it for a review that will change it potentially. If they have the numbers right, it may not change at all. Okay.
Yeah,
just make sure that you have your current pay stub available.
That's the problem. I don't have check stubs. I do.
You do 1099?
No, I work here and there with some of my friends, and I mean at the end of the year, sometimes I really don't even, get that much.
Well, you're gonna have to bring proof of some kind of income.
Okay, and how do I get that? I tell them to give me a.
You're the one that gets you're the one that gets the income. So you can either show it by bank statements on your deposits about what you earn.
I don't get bank statements though. I don't get bank statements. I don't get.
You do this all by cash?
Yeah.
You're gonna have to show. You're gonna have to show something, because they may hold you to an income.
How do I go about that? Do I gotta tell my the guy?
I don't know, because you're the one who's employed, not me.
I know, but ask the employer to give me.
Yeah, you can ask the employer to say how much he pays you.
I'm asking.
Yeah.
All right.
Yeah. Get something from your employer saying how much your income is. That would help.
All right. So now, when do we have court again, or what?
No, they're going to send it to the front of the court. The front of the court will be contacting you in the next 2 or 3 weeks to do a review that will go back to August 1st.
Okay.
All right.
All right. Yep.
You have a good day. Take care. Thank you for your patience. The reason that I was able to adjourn and invite the prosecutor was because you preserved the date back to August 1st. So it's going to go back to August 1st one way or the other. All right.
All right. Yep.
Take care.
All right.
Have a great
Yep.
weekend.
How do you get out of here?
Well, the door's right behind you.
All right. See you later.
Take care.
Right,
All
I
right.
still have only the moving party for all the cases.
All right. Which one do you want to do? Let's do DS. I have Ms. Scroggins available. Mr. Pearl did not show up. This matter was set for a hearing at 9:30. It's now 9:48. Ma'am, I've read your motion.
Yes,
it's kind of all over the place. You got a lot of concerns, and
Yes,
you've attached some pictures that validate those concerns, but I have no idea what you're asking for.
So I was told I know no one can really make no one do anything, but I need I need help with Mr. Pearl. I just would like for him to be able to do 50% of his parenting. Like I'm there for my son all the time, but it's so hard. I got a special needs son. He requires a lot of attention and everything, and I can't have Mr. Pearl jumping in and out. It's either he come 50-50 with me or just leave us alone, because every time I allow him to jump in and out, it's a setback to my kid, and it's a setback for me. It's like a dictation thing that he's trying to do. And
well, at this point in time, you have total control of parenting time. You can not let him have it, or you can let him have it. It's by your discretion. He has 0 parenting time, according to the court orders.
Yes, sir, he doesn't.
That have been entered since 2017. So for 7 years, he's had 0. All parenting time is at your discretion. So if you don't feel it's in the best interest of your child, you can just not do it.
But I don't want, because my son is like, but mom, he's my dad, and I love him.
Okay. Do you want me to send this to the front of the court for a parenting time?
Yes, sir.
Okay. That I can do. I can't make him a good father, though.
No, that's the only unfortunate part about it. So like, once the friend of the court get it, does that mean he will have to stand up to it, or it's just something that was put in?
I can't make him do it.
Right. That's why he said that. Okay.
Yeah.
Okay.
Which is why right now it's at your discretion. If I send it to the front of the court, there is going to be court ordered time. If he doesn't use it, then I will take it away and we'll be back to at your discretion.
Well, okay.
Right now you have control.
Is there any way that I can get it to where he could just leave us alone? Is there any way I can?
It's at your discretion, which means if you tell him, no, I'm not giving you any, then it's going to force him to file a motion to see if he wants parenting time.
Okay.
And he's going to have to show the court why that's imperative. And he's going to have to tell, and I'll be able to tell him, look, dude, you asked for parenting time. I will grant it specifically, but you better utilize it and be a parent on that time.
Yes, sir. I don't think he's going to do it, because that's why he stated the courts and people can't make him do this, can't make him do that.
But you can also tell him then there's no parenting time.
Okay, so this is my problem. Now, if I don't do this part, I can be like, okay, I got full custody.
Do you want me to suspend it until further order?
Yeah, but if
you put some things in here that were very concerning about his treatment of the child. So I can't, with what your allegations are in your petition, I can suspend his parenting time. I don't like to do that because, again, you have total control. It's reasonable as you agree. So in other words, if I suspend it, then you don't have a choice to say your kid wants to see his dad. So, you don't have the choice to say, it's Christmas, go on over, because I'm suspending it. Right now you have that ability. You can tell him no, you can tell him yes. You have control of this, not him.
All right. But that's the thing. Like, I want him to be able to take 50-50, but see, if he's not going to do it, then it's just a waste of my time, too. But I would like for him not to be able
and obviously 50-50 is too much for him to handle. Because he doesn't want to. And when he does, there is some concerning activity that he engaged in that may be detrimental to the child.
Right. So I really just wanted to just leave us alone. Like I don't want to be able to call me at any time of the night and say,
Again,
I want to talk to
you've put enough in here and said that I can suspend his parenting time if that is your request. You just made you just made no request. You gave me all this stuff and you didn't tell me what you really wanted. Possibly from talking to you because you don't really know what you want.
Right. I'm just trying to get it to where if he can't
I'd like him to have parenting time, but I also want the child to be safe, and it doesn't look like he's been safe with his father. He's been injured.
Yes, sir.
All right. I can suspend it and we'll see what happens. All right.
Oh, okay.
All right.
All right. Well, thank you and have a good weekend. Thank you.
You too. Take care.
Okay.
I love it when they give me several pages. But yeah, some of the pictures were not pretty. 46DS. I've read your motion. He appears to have vacated the previous home that he was in. When was the last time you saw the child, Miss Osorio?
The last time I saw the child was like, he just missed 3 visits prior to the court date, but then right after that, it was 3 visits prior to the 4th of July weekend.
Okay, so you've missed 6 visits?
He missed 6 visits in total.
And that's just all started recently. So when was the last time you saw the child?
The last time I saw the child was, to be honest, the beginning of August.
Okay, so you just saw him a few weeks ago. And then after that is when he disappeared?
It was, according to my son, I'm going to tell you this now. It was the last time I had a visit with him. He told me he moved into one of the cities in Michigan. That's all I know.
Okay, so how old is your son?
My son is 8 years old.
8 years old. And when did your son tell you this?
My son told me on the last visits about 3 weeks ago.
Okay, so that was the last visit in August.
Yes.
And he's not had any visits since?
Nope, he has not been.
How were these visits? Are they still through the Y?
They're through the YWCA, yes.
Okay. All right, here's what I need you to do. I will check on the address to see if we have a current address. Okay. But you need to show that you've been going to the Y and he's not been complying, and you have the right to file for a parenting time show cause through the Kent County front of the court. Okay. If he does not have a reasonable explanation, they will set up a hearing where he can be held in contempt for non-compliance.
Okay.
Just like we hold people in contempt for not payment of child support, we hold them in contempt for not following through with parenting time orders.
Okay.
But file through the front of the court. They have a special department that does this, and they can assist you in doing that. That's what their job is. Okay. Because if he's non-compliant, he's in violation of the current court order. All right. And I will see if I can check on his current address and if it's appropriate to release that to you. Okay.
Okay.
But right now your visits are not through the house, they're at the Y. So you have to keep complying with the Y and show that the Y is, that they're trying to get a hold of him and he is not showing up.
They have been trying to get a hold of him. The last visit I showed literally was like last week, and I did.
Keep following through and then file for these show cause hearings on all the ones that he's missed.
Okay, then I will.
Because he's not in compliance. And then I think at this point in time, you've been doing YWCA for years.
I know, but yes.
I think at this point in time, it's time to send this for a parenting time review.
Okay, then.
All right. That way, both of you will have to participate in that. Because we don't hold you to supervised parenting time generally it only lasts a year or so. Now, you indicated Child Protective Services involved. Why?
Okay, so Child Protective Services called me and told me that the school called because my son was being abused by his dad. That was February of last year.
Oh, okay. So that was months ago.
That was months ago. but I didn't hear nothing from them
Well,
after
in that case, they must have not found anything because they would have told you.
Okay, well, I should have told front of the court. My bad, but
Well, it may or may not have amounted to anything. Accusations can sometimes be made. The front of the court then investigates and finds out it's nothing.
okay,
And if they found out it was something, normally they follow through within 30 days.
okay,
So I'm sure, you can feel free to contact that child protective services worker to find out the update.
okay.
All right. But please contact the front of the court parenting time show cause department and with dates and times that there was non-compliance, and then I will send this for a parenting time review.
Thank you.
And I've looked at the income, fees are waived. All right.
Alrighty, thank you.
Take care. Good luck.
Thank you.
Child Protective Services has been involved in that case way too much. I would quit splashing coffee back in my face. 078D. Next.
Williams versus
all right, Mr. Williams, when was the judgment of divorce entered?
2000 and I want to say 2 summers ago, like in
2022.
Yeah.
Hold on, let me ask. Ms. LeVay, the court file never made it to me. That's why I'm asking him the question, because I was hoping he'd have the answer. But can you pull up court view and find out when the judgment of divorce was entered, please?
Yes, one moment.
Thank you. All right, because we're dealing with a child that is 1 year old. How have they determined that you're the father?
That's what I'm trying to figure out. It's
okay,
just...
the standard is that if a child is born within 10 months of the entry of a judgment of divorce, it's presumed that the child was conceived during the marriage.
Right, and this child is outside of 10 months.
That's why I'm trying to determine when, because I'm like, how the heck did they make you the father?
That's man, bro. We on the same page.
Because if the 10 months it's from date of conception.
Because he just turned 1 in 2024.
Right. Yeah, that's why which means he would have been conceived, I would think, in 2023. Then if you were divorced in 2022, I think we got a time problem. I may have to, I may have to order a hearing though, where I bring her in because I want to hear from her and what the heck's going on. That way we can find out what happened. So I may need something more than just this morning. Yes, Ms. LeVay, when was the judgment of divorce entered?
July 20 of 2022.
Okay, and how sure are you that he's 1 year old and not 1.5 years old?
Who, me? I'm 100% sure.
Okay, when was his birth? Do you know when his birth date was?
Like March 29th.
Okay, so that would have been 3. That would have been June of 2023 that he would have been conceived. This makes absolutely no sense.
Yeah, and she has nothing to do with that. The court. This is the court's doing. She didn't.
Well, the court wouldn't have done it. So how did the court? Is there a DP case or something that makes you the father?
Yeah. So basically, he never signed off for the babies. So they're trying to say I'm an alleged father.
Okay. Whoa. They're trying to say you're an alleged father. Is there another case going on right now?
It was another case. So
there wasn't. Okay, so this is not in your. Okay. Yeah, I am going to have a hearing. Do you know what the other case was? What number it was?
No, I don't.
All right, we're going to pull that file. I'm going to invite her. And if I need to, I'm assuming that would be a prosecutor's case.
Well, so basically, this court case just allows me to get a DNA test, which would be totally fine.
Well, if the timing is off, I may not need a DNA test. That's why I want her here to testify.
Oh, okay.
Because I mean, if this child was conceived a year after you were divorced and you haven't been physically with her since the divorce, how the heck are you the father?
Yeah.
Yeah, I generally need you to provide DNA twice, once for the conception and once for the testing. So, if you didn't provide the first one, I don't think I need the second one. Alrighty, so I will set this for a hearing, and I'm going to hunt down the other case and find out what's going on. All right, so I'll see you in about 3 weeks or so. It shouldn't take me too long.
All right.
And then we're going to invite her because I want her testimony on this and find out what the heck's going on.
Okay, thanks.
No problem. Yeah, this one's going to have to be worked out. I can't do it on a Friday morning that easily. But I'm on the page with you. I'm like, how the heck did they make you the daddy?
All right, thank
you. You have not slept with her since the divorce, right?
Not at all.
Okay, just thought I thought I'd better ask that question first because I don't want to get to this hearing and you say, well, yeah, we were kind of
no
engaged. Okay, like I said, if you didn't donate the DNA for the conception, I don't think we need a DNA to prove you're not the daddy. But we'll see about timing and stuff. Okay, but if I have both of you under testimony swearing that you guys haven't physically been together, then we'll see you then. All right.
All right. Yep.
Hold on. Let me see. My clerk, I think, has sent me a chat. She may have given us a time. If my computer will comply with letting me see the chat. Are you offering the 10/16 at 2 o'clock, Rebecca, for this case?
Yes.
All right. How does October 16th at 2 o'clock sound, sir?
That's fine.
All right. By Zoom, and we will invite the mother as well. And I'll see if I need to invite the prosecutor depending upon the other case. All right?
Okay. All right,
Have a good day.
Yes. Yep.
We are here on a motion brought by the Kent County by the Kent County Prosecutor's Office on behalf of DHHS. The state has requested this case. Neither one of you did. Because there's state aid involved, the state mandates that if state aid is involved, the child support must be set by law, and then the state confiscates part of the child support to reimburse the state for the state aid that it gives to the child. So what I will do is I will let the state proceed with their motion, and I'll hear from each of you. Okay, Ms. Smith-Lowe, if you care to proceed, ma'am.
Yes, Your Honor. As the court is aware, this case was filed on or about, actually on May 31st, 2024. Service was proper on Mr. Is it Walker Cantu?
Yeah.
Okay.
Yeah, Walker Cantu.
On June 25th, we received a response and a pre-hearing conference was scheduled on August 7th. I held a pre-hearing conference with Miss Nugent. I was unable to reach Mr. Walker Cantu. The calculations were based upon, for one child, were based upon her actual income of $19 an hour at 32 hours a week, with 365 overnights and one other child, and paying $93 a week in childcare, nothing in healthcare. And Mr. Walker Cantu's actual income of $21.99 at 40 hours a week with no overnights, and him paying $66.64 a week in healthcare with one other child and nothing in childcare. Birth costs are waived. Uninsured medical split is 44% plaintiff and 56% defendant. The calculation for one child is for a base support of $497. There's a healthcare premium adjustment of $43 for a subtotal of $454, ordinary medical of $21, childcare of $190. There's no deviation for childcare in this case, and for that comes to a total of $665. We're asking for entry of the judgment of support and UCSO as proposed.
Certainly. All right, Ms. Nugent, you're the plaintiff. Any comment, any input?
Other than the overnights have changed since filing.
Okay, what are they?
It's been 2 overnights a week.
Okay, so 2 overnights every week or 2 overnights every other week?
Every week.
Every week. Okay, so that would be 104 overnights.
Yes.
Okay, we can, Ms. Smith-Lowe, if you could plug that into your equation.
I will.
And then Mr. Walker Cantu, is there any input that you have?
No, we can do, but I'm sorry about that. We can start doing 3 nights after the hearing.
Well, right now it's at 2. Right now it's at 2 nights, so that's what I'm going to hold it to. I don't speculate.
Okay,
if you're actually doing 2 nights, and that's what is going to be happening, then that's what we'll hold it to.
The healthcare there was healthcare applied under like my insurance, correct?
No, because we didn't have anything from you.
Yes, I did.
Oh, you did?
Okay. I had his actual wage verification. I just wasn't able to reach him for the pre-hearing conference.
Oh, okay. So we actually had his pay stub. I'm sorry. I mistook that. Yeah, you're right. There is a premium adjustment for you paying health insurance.
Okay.
Now, that brings support to $543.
Yeah, I was going to say the overnights aren't going to affect it much. It's based primarily on your income, sir.
Okay. What about me paying child support for my first?
You are given credit for that child. She's given credit for one other child in her care, and you're given credit for one other child in your care. You were given $493 in credit for that child per month.
Okay.
All righty. We try and set it. Like I said, it's got to be set by law. So now that we've adjusted it with the proper parenting time, that will be the entry of the court. And again, child support, custody, parenting time are always we can relook at them under certain circumstances till the child is 18 and out of high school.
Okay, so just quick question. So with me paying $500, I don't have to pay for daycare or anything like that.
That's involved in the calculation.
Gotcha. So
how the calculation works? How the calculation works is it calculates how much she pays per year. It takes out her tax benefit that she gets at the end of the year. It then multiplies it by your percentage of incomes so that you each get a pro rata hit, and then it divides it by 12. Because sometimes daycare is higher in the summer than it is in the winter, so that's why they take the year average.
But for our child alone, we're both splitting the daycare, so she's not paying 90. She's actually paying 60.
We just started doing that.
Oh,
but
hold on. What?
The $93 that she's paying is for her older daughter and our daughter. So for just our daughter, she's only paying 62.
That's not what was shown. That's not what was shown to the prosecutor. The prosecutor only took into account what was paid for this child.
But if she's not paying 90 a week,
that's what was shown to the prosecutor. That's what was shown to the prosecutor.
That's for both of her daughters.
That's not for. That's
How
not
are you
for
paying
both.
90 and I'm paying 60?
That's the total. That's the total. That's the total.
Hold it one at a time, please. Don't talk over each other. Thank you.
She goes to daycare 4 days a week, and it's 124. 124 divided by 2. That's what I'm paying. $62 a week. So I don't know how.
Miss Nugent,
I don't know how.
Can I ask her the question? Thank you, Miss Nugent. What is this? What's happening?
She goes 1 week. She'll go 4 days, and 1 week she goes 3 days. For the 4 days, it's the 120, and for the 3 days, it's 93.
Okay.
And then the last month or so, we've been splitting it. Maybe a month and a half, 2 months, maybe.
Okay, so you guys are going to split it outside the guidelines?
With child support being instated, no.
I'm sorry, I couldn't hear you because you're talking over one another again. Miss
I
Nugent?
apologize.
With the child support being instated, we wouldn't be splitting it any longer, no.
Okay, so you're going to pay the entire thing?
Correct.
Okay, and that way, Mr. Cantu, you're not paying anything anymore. It's in the child support.
I just know that on file you said that it was 90 she was paying, and it was.
It sounds like 90 and 140 on the other week.
It was
or 120 on the other week.
Correct.
$93 just for her.
All right. In any event, the daycare provider provided the prosecutor the proof, and that's what they went with. And it's only on the one. It's only on the child that they showed was paying for that. That's all that's included.
It doesn't make. This really doesn't make sense.
Well, it's mathematically put into account. So, all righty, you're not paying child support directly anymore. It's going through the child support. All right. Good luck, everybody. Have a good morning.
Thank you. You too.
Okay.